So, you've been raising someone else's child for quite a while now. You might be stepdad or stepmom. You might be the grandparents. You might be great aunt, great uncle. You might have no relationship to this child at all, but you have somehow come into possession of the child, and the child's been living with you. You're paying for the child's financial needs. You're providing all of the child's emotional, physical, and psychological needs. You're making sure the child's getting a good education. You're thinking, sure wish I could adopt this child. I could make him safe forever then. But you're afraid to rock the boat. This video is for you. My name is Carla Hartley. I am an attorney licensed to practice in Texas and California. I'm the managing partner of a firm of attorneys licensed to practice in Texas and California. We practice family and estate law. At our firm, we've successfully guided many families through step-parent and independent relative adoptions over the years. I have a special heart for step-parent adoptions, especially in situations where the other biological parent has more or less abandoned the child. So many loving step-parent and parent couples live day to day with this uncertainty, never realizing they can make that bond with this child permanent and legal. The process usually starts by filing a petition for adoption. In California, this pleading is titled an adoption request under Family Code Section 9000 and following. With parental consent, the adoption can often be completed in about 60 days, and the final joyful hearing is just typically 15 to 20 minutes, if that, frankly. Without consent of the out parent, we have to proceed with a petition to terminate his or her parental rights. It's always worth a call to find out whether solid grounds for termination exist, what any difficulties might look like, and if there are shortcuts available in your specific situation. Consent is wonderful when it happens. We use the proper judicial counsel forms, witness correctly, depending on whether signed in or out of state, and yes, there is a difference in California. When consent isn't given, we help prove grounds under Family Code Section 7820 to 29, or for guardianships which have been in place, under Probate Code Section 1516.5. Common grounds include abandonment under Family Code Section 7822, failure to support or communicate for a statutory period, neglect, a felony history, issues involving substance abuse. Sometimes merely the existence of a guardianship of over 2 years is sufficient to start the petition to terminate parental rights. We have found that generally, a lot of these issues will appear concurrently. The court only needs to make a finding to terminate parental rights under one of the available grounds. But to succeed, the parent who's opposing the termination of parental rights has to win on every ground. This gives us a large advantage if we have the evidence. In these cases, for termination of parental rights, we have to be evidence-driven with the request to terminate parental rights, because we are essentially asking the court to excise a parent's constitutional right to be involved in the care and custody of their child. We like to say our courts always focus on the child's best interest, but where constitutional rights are involved, we have some significant hurdles to overcome before best interest becomes the court's primary consideration. With our firm's experience handling so very many of these cases over the past decades, we guide families thoughtfully while protecting all of your rights and the children's rights to a stable, safe, secure home. A lot of cases involving termination of parental rights and adoption get hung up on something called the ICWA inquiry. The United States has treaties with the American Indian nations, and out of those treaties, ICWA, the Indian Child Welfare Act, inquiries are mandatory. California's legislature has codified ICWA to require continuing and comprehensive inquiries of family members who may have knowledge of the child's ancestry. So along with your petition, you'll need local county citation forms and the required ICWA inquiry forms regarding any Native American ancestry. County or state agencies will complete an investigation and report, but that does not end the continuing duty to inquire in California. Importantly, we also make extra efforts to ensure full compliance with the Indian Child Welfare Act. This is a federal law, 25 U.S.C. 1901 et seq., that California has strengthened in its family code. Plus, the mandatory judicial council forms have been established and required by the Judicial Council of California. These are not optional, they are required. We perform a thorough inquiry about any Native American ancestry right from the beginning. This step is vitally important. Doing the ICWA inquiry correctly protects tribal rights and, more importantly to you, safeguards your adoption so it cannot be successfully challenged or later delayed via the appellate process. We take this very seriously so your family's legal bond can be secured forever. From our experience handling so many of these cases, we know exactly what the court expects, so the process goes as smoothly as we can possibly make it. Again, my name is Carla Hartley, and I hope this has been helpful.